Get ready for the dictation. Start. No counter affidavit has been filed by the Learned Standing Counsel as the case was heard on a pure question of law as to whether, when the final report was submitted on the approval of the district magistrate, then could the order of termination be upheld, which also was passed after the approval of the district magistrate. Learned Standing Counsel had made his oral submissions. Learned Standing Counsel had submitted that the inquiry by the licensing authorities was based on the doctrine of preponderance of probabilities, whereas the investigation by the police and the acceptance of the final report submitted by the prosecution were not based on the doctrine of preponderance of probabilities. Learned Standing Counsel therefore submitted that the fact that the final report was submitted and that too on the basis of the permission granted by the district magistrate would not affect the order of termination, which was upheld by the appellate court. Having heard learned counsel for the petitioner and the Learned Standing Counsel, I find that the first information report had preceded the show cause notice. I also find that virtually all the charges levied on the first information report was similar to the charges made on the show cause notice. I fail to understand that when the prosecution had found that the petitioner was not guilty and this finding was affirmed by the district magistrate, then how to order of termination could stand. I also find that there are virtually no application of mind by the district magistrate when the approval was given before the termination order was passed. In fact, malice is writ large. On the one hand, approval for the termination of license was granted by the district magistrate, and on the other, he gave his consent for the submission of the final report. I also find that the inquiry was not conducted in the manner as was contemplated in the relevant government orders. No time was fixed when the petitioner could have brought her witnesses to rebut the evidence placed by the licensing authorities. I also find that no place was ever fixed where an inquiry had to be conducted, since in the decision rendered by the Supreme Court in Poonam versus State of UP and others reported in 2016 to SCC 779, it has been held that an allottee who had been allotted a shop during the pendency of the litigation had no right to challenge the restoration of the license. I find that there is no requirement to heard the subsequent allottee, and therefore the writ petition is being allowed in the absence of the subsequent allottee. The orders dated 28/3/2018, 4/12/2018 and 30/4/2019 by which the license of the petitioner was suspended, the license was cancelled, and thereafter the appeal was dismissed respectively are being set aside. The license of the petitioner to run the fair price shop shall now be restored. The writ petition is accordingly allowed with the aforesaid observations. Stop.